Hello friends, I am Dr. Harsha Suryamshi, Associate Professor from Sri Shivaji Law College, Parbhani. In previous lectures, we discussed provisions about Works Committee, Conciliation Officer and Board of Conciliation under the Industrial Disputes Act. In the present video, we shall discuss provisions about Courts of Inquiry under Section 6 and some of the provisions of Labour Code under Section 7. Section 6 speaks about courts of inquiry. The appropriate government shall constitute a courts of inquiry. The name itself indicates object of court of inquiry. The object is to inquire into any matter relating to the industrial dispute. The court of inquiry shall comprise one independent person or any such number of persons as recommended by the appropriate government. As regards procedure of courts of inquiry is concerned, if there are more than one member in the courts of inquiry, one of them shall be the chairman. That means if there are two or more members, then out of these two or more members, one shall be chairman of courts of inquiry. The quorum shall be decided by the appropriate government according to the number of members in the court of inquiry. Therefore, the court can act even in absence of chairman if required quorum is present. As regards Labour Court is concerned, now we are switching over to adjudication mode for settlement of industrial disputes. The provisions regarding Labour Court are given in Section 7. The appropriate government shall constitute one or more labour courts as required by that area. The appropriate government shall constitute the labour court by notification in official gazette. The primary function of labour court is to adjudicate industrial disputes. That means settle the industrial disputes by application of law relating to the matters specified in second schedule, and the labour court can perform other functions as stated to him. In labour court, there shall be only one person who shall be presiding officer of the labour court. The presiding officer shall be appointed by the appropriate government. Now, who can become presiding officer of a labour court? A person who is or who has been judge of a high court is eligible to become president or presiding officer of labour court. Similarly, a person who is or who has been a district judge or additional district judge for at least 3 years is also qualified to become presiding officer. If any person has held any post of judicial officer for at least 7 years, is also qualified to become presiding officer of labour court. A person who is or who has been presiding officer of a labour court constituted under any provincial or state act shall also be qualified to become presiding officer under the Industrial Disputes Act. Now let us see what is the jurisdiction of labour court. The territorial jurisdiction, that is jurisdiction with respect to territory or area, is concerned, it is specified by the appropriate government. Now, what are the matters that can be decided by the labour court? These are the matters which are specified in the second schedule of Industrial Disputes Act. I have referred few of them here. If there is a question about legality or illegality of strike or lockout, then such question can be decided by the labour court. If any customary concession or privilege was going on for a longer period, but the same was withdrawn and a dispute arises, then such dispute can be settled by the labour court. If any workman is discharged or dismissed, then discharge or dismissal of such workman can be decided by the labour court. Thank you friends for watching the video.